a property here in South Florida, they're Canadian. Is it different if it's a rental property or a personal use property? Does it matter?
Great questions, and I'm glad you brought it up. I'm literally dealing with that exact situation as we speak. So we'll start at a high level. Typical sale of a property owned by a Canadian. It doesn't matter if it's residential, it doesn't matter if it's commercial, it doesn't matter if it's an investment. If you're selling a property as a Canadian, you are going to be subject to FIRPTA. FIRPTA is a tax withholding that essentially the U.S. says you're not going to pay any capital gains tax on your sale because you don't pay taxes in the U.S. So in order for the U.S. to get some tax revenue, we're going to hold back, generally speaking, 15% of the sale price of that property. There are some exemptions to that rule. If you're selling a property that's under $300,000 and the buyer is using it for at least 50% of the time for the next 2 years after closing as a primary residence, we can get an exemption from that FIRPTA withholding.
And that's interesting because it's the buyer is using it for the next 2 years as their primary residence, right?
At least half the time. It's a very complex, nuanced rule, but the short and sweet answer is you don't control, of course, what that buyer is going to be using the property for. So it's very good to have that conversation up front with your agent. Your agent can talk to the buyer's agent, get an understanding of if your property is going to be subject to this withholding, and that's completely dependent upon whether the buyer, who you have no control over, how they're going to use your property at closing. So if they're buying it in an LLC, by default, FIRPTA is going to apply, because if the buyer is an LLC, it can't be a primary residence. So that's a red flag right there to note. If an LLC comes across your way as a buyer on a contract, you need to be aware FIRPTA is going to kick in.
Okay.
So interesting. We actually dealt with this, I think, earlier this year.
Probably a few times.
Yeah, but one recently where the seller and the buyer were both Canadian, and the seller wanted them to sign something saying that it was going to be their primary residence, so they didn't have to be subject to the FIRPTA, and it was a $300,000 transaction, so it was right at that limit. Remember the condo here on the beach? I forget the other agent's name. So what I never quite understood, and help me out because I've always wanted to ask you or somebody this, is like, why does it really matter what the buyer's using it for? Is it because they still have to pay the taxes, right? Is it? I understood this, right? I heard that the IRS can come back to the buyer and ask for the tax revenue if the seller doesn't pay it.
So that's right.
Like, so why does it really matter with the new person coming in if they're going to live in it or sell it or whatever?
Think of it like this.
The seller's the one that's got to pay.
Yeah, but
right?
Think of it like this. So we have similar rules in Canada, right? So it is the person remaining in Canada that is going to ultimately be responsible for the tax, because Canada cannot enforce a tax law outside of its own jurisdictional borders. That's so right. To me, it makes sense.
Why would I, as a buyer, want to take any risk?
Well, you have no choice. That's the law.
No, you do, because the buyer has to voluntarily sign this addendum.
Oh, I see what you're saying.
That says, I'm living in this, and you're good with not doing the 10% withholding.
Think of it this way.
Why would I ever? I don't know the seller. I don't know their accountant. Right. Well, I don't know if they're going to
think about it this way.
$30,000 to the government.
The U.S. government wants to make sure it gets its share of tax revenue. However they get it, they want to make sure they get it. They don't care who they're collecting it from. But if that foreign seller moves back to Canada, once they're back to Canada, they're not going to be subject to U.S. taxes. So the government says, okay, buyer, you are now in Florida. You are now the owner of this property. We're going to come after you, and you're deemed the withholding agent is the term they use. You're going to be subject to this tax if we find out through an audit or other means
that guy never paid,
that tax was in fact due, and we can't now go after the seller. You're on the hook.
Yeah. So again, right? Why would you ever, as a buyer acquiring a property from a non-resident, even give them any opportunity to be off the hook?
Well, that only applies in the limited exemption circumstances where it's under $300,000 and you truly are going to live there. If you're a Canadian planning on moving down here and you're going to live in that property 50% of the time or more for the next 2 years, and you truly are, there's nothing wrong with signing it, just like anything else. If you're going to truly do that, you can sign it. The reason, I get what you're saying.
But there is. Maybe I'm missing something, right? But I'm a Canadian. I sell you a property. You're American. Right? You're going to live in it as your primary. I don't pay the taxes because you signed this piece of paper because it's an exemption rule, right? IRS is going to come to you.
There's no taxes due.
What if there's taxes due?
There's no taxes due. There's an exemption. That's what I'm saying.
So under 300 grand.
Under 300 grand and the buyer signs that document, there's no tax due.
There's no taxes due.
Period.
Ah.
That's why it's not a risk.
Okay. Got it. So I always understood that there was still taxes due.
No, it's a carve out.
Okay, cool.
It's a carve out.
I learned something.
Perfect. Okay.
That's great.
I guess the main point that people have to understand is you sell a property in Florida, you're not American, FIRPTA could come into play, and the people that are going to be interested in this are going to be buying properties over $300,000, right? So FIRPTA is going to come into play. There is going to be a withholding tax. You probably are going to have to file some form of, pay some form of capital gains tax here in the United States, and then that will release the remainder of whatever is sitting in the lawyer's trust account, right? Or whatever's sitting in escrow.
And I'll piggyback on that. And that's right. So you sell a property, the sale price is more than $300,000.
Right.
FIRPTA is applying. There's no exemptions at that point. It's just a matter of if it's 10 or 15%. And there's some nuances to, again, how the buyer is going to use it. And if it's under $1 million, we can get a reduction down to 10%. If buyer signs the primary residence affidavit and it's under $1 million, we can drop the 15% down to 10. That said, over 300,000 Canadian sellers should be expecting a 10 to 15% tax based on the sale price. Now, that said, that doesn't mean that that's the tax that they actually owe. That's just the preliminary figure that we have to use to calculate it before we actually dive into the financials. In order to understand what the true tax liability is for that seller, they'll often hire a CPA, or they'll hire a firm, perhaps FIRPTA Solutions, or one of these firms that specifically focuses on FIRPTA transactions. They'll dive into the basis of the property. They'll understand your costs, your expenses, any capital improvements you've put back into it to get a true understanding of, I bought it for this amount, I put this amount of capital improvements into it, I sold it for this amount. This is actually my tax exposure. It might be quite less than the 15% that we as attorneys have to hold back in trust. Now, that requires, of course, filing the appropriate paperwork to the IRS, showing them the paper trail of why you only owe a certain amount of money. And then once the IRS receives that paperwork, they'll usually make a determination. Of course, they're not the quickest, but 6 months to 12 months, depending on how quickly your particular auditor is, they'll give you a ruling and say, okay, we agree with your calculation, or we've recalculated it to be this, and they'll send back a letter saying, okay, perhaps I held back in trust $100,000. If the taxes owed are $50,000, I remit the $50,000 back to the seller, and I pay the $50,000 to the IRS. Now, again, without getting into too much specifics, the closing agents, the attorneys, we have to remit that FIRPTA withholding to the IRS within 20 days of closing the transaction. We are allowed to not mail it and hold it in our trust account as long as you file what's called a withholding certificate, essentially these forms to the IRS, letting the IRS know you're aware, you're going to be submitting your documentation as to why your taxes owed are not the flat 15%. I still have to withhold the flat 15%, but I can hold it in trust, and getting it back from me is going to be a lot more simple than trying to get it back from the IRS.
Right. So you're going to want to sign that paper to
That's
get
right.
that paperwork done.
It also depends on sometimes how close you are to the tax cycle and when taxes are due.
That's right.
Right. We've had a seller of a Canadian property that said, you know what, I'm not going to go through the whole process of filing a withholding certificate because taxes are due in like 2 months, and I'm just going to file it
Anyways,
and I'm going to get my return.
Right.
And the person was one of the parties was American.
Right.
It was
But I guess the overall
mom and
point
daughter.
that I wanted to drill in here, I mean, nobody's going to be able to figure out how to do this crap themselves. It's too complicated. The idea, though, that I want the Canadian investor to understand is it's not a straightforward process. Like when you sell a property in Florida and you are a Canadian, there is a withholding tax. anything above $300,000, there's going to be a withholding tax, and it's not a straightforward process to simply get that money released. You're going to have to file U.S. tax returns, calculate your capital gain properly, get an assessment by the IRS or an approval of the calculation by the IRS. And once that is done, if there is anything left over, then the money will be released to you.
That's a great summary.
Okay.
And like you said, it's not simple and straightforward. There's a lot of very, very stringent deadlines that have to be adhered to. There's a lot of specific paperwork that has to be, properly filled out, timely filled out. So whenever you're selling property, probably even more so than buying, but both sides of the coin. Whenever you're buying property in a foreign country, think about it. Would you go buy property in a foreign country without a local counsel or a local attorney?
Of course not.
Guiding you and explaining all the nuances? I mean, the standard as-is contract that we sign, that Vito fills out for his buyers and sellers, that we see 99% of our contracts in Florida come into our office. It's an as-is contract. It's 13 pages. It's pretty detailed, but it's a boilerplate form that outlines the general scope of the transaction. And somebody from another country who's not used to maybe as litigious as Florida is, to segue into that, Florida is an extremely litigious state. We might be the most litigious state in the country. I know South Florida people sue people for anything and everything over the most nitpicky things. And escrow disputes over the buyer's deposit happen all the time, whether they're justified or not. Just because a buyer wants to back out of a deal, maybe they feel like they should be able to. Maybe they feel like it's justified. Maybe they feel the seller lied, misrepresented something, committed a fraud. That all may be true. But at the end of the day, until a ruling is determined, that escrow deposit has to sit in my trust account until somebody decides through a court process, a mediation, whatever it may be, that this is how we're going to release those funds. So to kind of get into that, the litigation side of things, Florida is extremely litigious, and you're often dealing with people who are not reasonable. And if you don't have proper counsel, both on a real estate side and an attorney's side, you can find yourself, in a sticky situation. And if you're a buyer, your deposit, and often six-figure deposits, tied up for months and months on end, and you're not getting any interest on that money. It's held in my trust, and you can't use it for any other purposes until you resolve that dispute. So it's definitely something to make sure, if you're going to buy or going to sell, have an attorney review the contract, jump on an initial call to have an understanding of what are your rights, what are your responsibilities, what are your obligations. Always happy to do that. Of course, I do that every day, talking to buyers and sellers about, should we add this clause in the additional terms? Should you be aware of this? Explaining FIRPTA. So it's definitely always better to have an initial consult with an attorney before you sign, because once a seller signs a contract, this is an important point. Once a seller signs a contract, there's no backing out. A buyer has often 10, it's negotiable, but anywhere from a 5 to a 15-day inspection period, which is essentially a cancellation period. That term is, of course, negotiable. You can waive that, which is not recommended. But if you're buying a property as a buyer, you do have in the boilerplate contract a right to inspect, which gives you an ability to cancel if you're not satisfied with the condition of the property. Once the seller signs, they're obligated to sell the property at that contract price. They're, of course, obligated to deliver free and clear and marketable title, but they can't back out. They can't have a change of heart. Once a seller signs, they're committed to sell, or they're going to be liable for, potentially liable for.
So injunctions are common, like to have a judge enforce a contract, then it would be straightforward, or is it still? I know you're not a barrister, right? Like you're not a litigator, are you?
I'm not a litigator, but there's two remedies in the contract. And again, maybe this is getting too deep into the weeds, but if you have a contract dispute regarding the purchase and sale contract for the property, there's really two avenues you can explore as a buyer or as a seller. Frankly, the contract outlines the remedies. But if you're a buyer and your seller decides, I'm not selling this property to you, I had a change of heart, I don't want to sell it, I don't like you. Right. Whatever their reasoning may be, if they're not signing on the dotted line at closing, you really have two options as a buyer. You can take your deposit and go home, or you can sue for specific performance. You could also sue for monetary damages. Usually buyers don't have that many costs that have racked up sometimes they'll have an appraisal cost
Right,
and
right.
some
Or
inspection
not
costs.
really not
You
worth
throw
it.
that in or whatever.
You could throw that in. Usually that's relatively small amount of money relative to the scope of the transaction, you know, $1,000 or two. There are times where you've incurred moving costs, you've hired movers, you've moved all your furniture. Now you have storage costs to store all your
Sold
furniture.
your house and you
And
now
you
where
might
are
have,
you
now
gonna
you
live?
might have to
And-
rent a property if
And
you're.
what about market value has increased?
Right.
These are all.
Like
These
maybe
are
you have a
all.
long closing period and
Yeah.
something happened in the economy and now that house is worth 20% more.
Got it.
And they don't want to sell it.
And that's an issue that, you know, we ran into probably more so back a few years ago when the market was rapidly increasing month over month. A seller would sign a contract, you know, call it in May, and then fast forward to July when it's the closing day. That property's worth $100,000, $200,000, $300,000 more. That
Right.
seller says, "I'm not going to close. I'm going to resell it for $300,000 more." The buyer, of course, is saying, "No, you're not. I'm going to sue you for what's called specific performance, which is their right to enforce the contract." They have to bring that lawsuit to the court. The court has to, of course, hear the case, and the judge would then have to rule that we are enforcing the terms of this contract. The seller's obligated to sell at the contract price.
Right. And is that I mean, look, court here has got to be something similar to court in Canada. It's a lengthy, expensive process.
That's right. It's not fast. It's expensive. You're going to have to hire a litigator. You're going to have to go through the motions, literally file motions, go through the typical litigation process. And at least down here where we are in South Florida and Miami-Dade and Broward and Palm Beach counties, tons of population, tons of lawsuits. So you're going to be put into the queue, and you're not getting that resolved in a month or two. That's going to take time. And oftentimes buyers, when they speak to a litigator, they realize unless it's a very unique property where they really want to make sure they get it and they have the wherewithal to afford to fight the case through the system, they just decide, I'm going to take my deposit and go home. Or oftentimes I've seen a couple of times in the last few years where a buyer will say to a seller, you know, cut me a check for X amount of money. I had a seller cut a check to a buyer for $50,000. And they said, give me $50,000 and I'll sign a release of contract and we'll go our separate ways. So there's ways to settle with anything. And oftentimes it's not worth pursuing a formal legal action.
Right.
Yeah, like I've seen buyers that were in the right, clean contract, and the seller being unreasonable and misinterpreting a term of the contract and just saying, nope. And the deposit was so small, it was like $20,000.
Yeah.
And it was like, by the time you go through the process, the
drained
buyer just
everything.
was like, okay, let's just split it. I'll take 10, you take 10, we walk away. And it's a shame, right? When you see something like that.
And everybody just wasted their time and their energy and their efforts.
Right.
And fast forward and nobody walks away happy.
Okay.
And that's a pretty common.
So I think from a summary standpoint, like you're buying a property, it's not until that title has transferred over to you, don't count your chickens before they hatch.